colleague, Professor Lisa Freudenheim. She is an expert in coaching, mentoring, helping people to learn how to study law. We've taught classes together. It's always been a pleasure. And so as this evolved, we became co-chairs in the planning for this program. She's been a delightful person with whom to work. She will introduce the speakers for the second half of the program, and then we'll, in the last slot, why she will try to work with our special guest, Fernanda Nicola, to draw our thoughts together. So please, will be just exactly 10 minutes behind the scheduled time, but we can end at 20 to 6.
Thank you, Professor Monser. I'm really honored to be a part of this conference and to be part of the afternoon panel. We have more students here than we had in the morning and or the early afternoon. And as I've said to the students, you're going to hear a lot of interesting thoughts, and you want to pull out themes and try to learn about different areas of law and ask questions. And my students said that they will ask questions, so be prepared. Not that we would expect that from our law students. So I'm delighted that they're all here. We're going to begin with Professor Mila Sahoni, who's going to talk first and then take questions, and then we'll move to Professor Veltri, and then Fernanda Nicola. Professor Nicola and I will also do a wrap-up session in which we'll try to actually answer the questions that were posed in our very lofty conference documents, the one around the law school that says, what kind of lawyer do you want to be? I think you might maybe not have all the answers to that question when you leave here, but you'll have a starting point. And so I think just being here, and I'm truly grateful that people have come and that you're open, because we have a terrific panel to listen to. So Professor Sahoni, and as Professor Monser mentioned, the bios are in the materials, and please do read them. These are a truly esteemed group of legal faculty who are here sharing their thoughts on legal theory, so there's a lot to learn from them. Professor Sahoni.
So I'm delighted to be here today, and I'm very happy to see so many students here in particular. I'm going to be talking today on the subject of crackdowns, which is a subject that spans theory and practice. So just over a year ago, in June of 2016, the Supreme Court issued an evenly divided per curiam affirmance in Texas v. United States. This was the challenge brought by Texas and 25 other states to the Obama administration's deferred action policies for enforcement of immigration laws. At the time, public debate over the Article 2 enforcement power was consumed with a singularly important question: the constitutionality and the statutory legality of the executive branch's efforts not to enforce the law, its power to waive or to defer enforcement in a programmatic, categorical, and prospective fashion. With a difference a year and a half makes. Today, the jackboot is on the other foot. The Trump administration is interested in active and targeted enforcement of the immigration law, not so much its waiver or non-enforcement. The Trump administration has announced crackdown after crackdown on illegal immigration, on leaks of classified information, on nonviolent drug offenders. In the offing may be crackdowns on medical marijuana and steel dumping, and still more crackdowns on illegal immigrants. Litigation over the travel ban has temporarily forestalled implementation of a crackdown on travelers from 6 Muslim-majority countries, but the ultimate fate of this crackdown is unsettled. As these crackdowns commence and unfold, they will affect millions of individuals and entities. Again, the contrast with a year ago is simple and stark. Then commentators were debating the validity of non-enforcement policy, the question whether the executive can dispose or dispense with a law that has been validly enacted. Today we are faced with the crackdown, which poses a distinct and much trickier question. Assuming the executive branch is enforcing a law that the legislature has enacted, what are the upper bound limits on how it may do so? Both questions matter for structural constitutional law, of course, but the latter question also matters for individual rights. A crackdown generates warrants, arrests, deportations, convictions, penalties, sentences. A policy of non-enforcement does the opposite. It leaves parties unscathed by government action. To the extent that one harbors doubts about either the system of criminal justice or the system of regulatory enforcement, then the crackdown has far greater worrisome potential than the conscious non-enforcement policy. So in the time that I have here today, I would like to introduce you to the crackdown and to explain to you how I think about it. First, I'll talk about what the crackdown is, the important role it plays in the toolkit of public law. Then I'll talk about some examples of how the crackdown can be deployed to subvert or undercut important values or in ways that serve the venal interests of the enforcement. And third and finally, I will return to discuss a bit more the Trump immigration crackdowns and to talk about how judges in particular have and might respond. So let me start with some definitional preliminaries. The crackdown is the voluntary executive choice to augment enforcement as to a particular set of offenders or of offenses. Crackdowns can take many forms and guises. Crackdowns regularly occur at the federal, state, and the local levels, and the crackdown can involve not only criminal law, but also civil and administrative law. And in my article, which I understand is over there, I talk through all of the squares in this table. I'll just talk about a couple of those crackdowns here today. So let's start with a very simple example of a crackdown. A mayor's sudden decision to enforce her town's 25-mile-per-hour speed limit very stringently, instead of continuing to let cars drive around town at 35 miles per hour, as has habitually been the practice of the town's police in the past. If the townspeople woke up one morning to such a world, they would experience it as if there had been a functional or constructive amendment to the legal rules that govern the town. The choice to crack down, the mayor's choice to crack down, is an act that more closely resembles law rulemaking than adjudication, and an act that more closely resembles law creation than law enforcement. And as rulemaking or as law creation goes, the crackdown is a highly unconstrained form. The town's mayor does not need additional legislative authority to implement a crackdown on speeding. The rules on the books already specify a 25-mile-per-hour limit. So there's obviously not going to be any bicameralism or presentment check on the crackdown choice. Prosecutors don't have to notice and comment a crackdown in criminal law, and on the administrative law side, these requirements of notice and comment aren't triggered unless the executive treats its enforcement policy as binding upon it, which it often does not. So what about the judicial, these are so what about the judicial checks on the crackdown? These are likewise light. Though an individual speeder may be able to challenge the facts of his own ticket down the road if he receives one, there's not going to be any independent adjudication of whether it was proper to make that top-level decision to enforce the speed limit strictly on a prospective basis. There's no grand jury or other institutionalized procedural check that's going to be monitoring that top-level decision by the executive branch to shift enforcement resources in this way. In sum, the crackdown choice, despite how consequential it is in translating the law on the books into the law in action, is thus one that is largely vouchsafed to the executive branch. As I argue in this paper, and as you also may have gathered from reading the newspaper, crackdowns can come with a lot of problems. So to get a feel for this, let's consider a couple of actual examples. So consider two tiny Florida towns, Lottie and Waldo, that sit on the stretch of Highway 301 that connects Jacksonville to Orlando. Over the tiny span of highway that these towns control, the police departments of these towns have doled out tens of thousands of speeding tickets annually to tourists and to snowbirds heading to South Florida for the winter. The American Automobile Association actually rented out billboards, their first ever, in order to warn drivers that this bit of highway was a known speed trap. So what was motivating this crackdown? It's not that driving at 56 miles per hour on that little stretch of road was somehow particularly dangerous. Instead, the answer was simpler. It was the revenues. The sums derived from these speeding tickets have been supporting the town's police departments almost single-handedly. The town's former mayor admitted as much to the New York Times. saying that it was filling city coffers rather than deterring the speeders that motivated the town's crackdowns. In fact, he admitted to annexing a bit of the road to bring it within the town's boundaries, specifically for this purpose. Well, there may be no technical, textual, statutory problem, right? The signs on the highway say 55. There's no technical, textual, statutory problem with the aggressive enforcement of these speed limits. What the problem is that the scheme is being used overzealously in a way that's both become unmoored from statutory purpose and is also unfair. Okay, let's take a look at another example. Another example of a problematic crackdown. So this is an article that was published a couple of years ago in the New York Times. In this and another article that was paired with this, the Times reported on nail salons, reported on the awful working conditions that were faced by manicurists in these nail salons. Manicurists working in New York nail salons were being paid pittance. They were being subjected to harsh chemicals in the workplace. They were being subjected to a ruthless ethnic caste system in which workplace perks and privileges were allocated amongst workers on the basis of ethnicity, even on the basis of skin tone. In response to the uproar generated by these articles, the mayor announced a crackdown on nail salons. Salon by salon inspections and a 6-language education campaign to inform workers of their rights. The governor then also invoked emergency powers to make those new rules effective immediately. So an intrepid journalist discovers abuse, and the government acts surely and swiftly to stamp it out. What could be wrong with that? But some reasons exist to be skeptical. Why now? A full year before the Times ran the 2 stories, the New York State Labor Department had conducted an investigation into nail salons and had found 116 violations in just 29 salons. But the crackdown, emergency enforcement measures for which we cannot wait, did not happen until after the Times ran its front page features. So the timing of the crackdown then raises some questions. As I just said, the State Labor Department had finished its investigation, which had revealed abuses in the industry a full year before the articles ran. Assume then that the state officials had some good reason for not doing anything substantive to respond to that finding in the subsequent year, for, as we say in the jargon, for allocating their enforcement resources elsewhere in that period. What exactly changed by virtue of the article's publication? The risk here is one of pandering, that an agent may select a policy because it is popular, even when the agent really believes a less popular policy is in the principal's best interest, even when the agent believes that a less popular policy would actually be the best use of enforcement resources. What it boils down to, in essence, is whether the state should determine how to allocate its enforcement resources based on what is printed on a given day on the front page of the New York Times. Throwing massive enforcement resources into a rip from the headlines crackdown will reap immediate political dividends, but at the expense of other enforcement efforts that the state officials might, in a vacuum of publicity, have deemed more pressing. So say enforcing labor laws to protect Uber drivers, or enforcing them to protect day laborers or janitors. From the perspective of the principal, that is to say us, the agent would have seemed to have delegated the application of its expertise and the exercise of its discretion to the media outlets. So as reflected by these examples and by others I canvass in the paper, crackdowns from federal, state, and local law can suffer from a wide range of principal agent apologies. Sometimes crackdowns seem to be driven by shirking or laziness by the agent. Sometimes they seem to be driven by the enforcer's impulse to pander to the media or to certain subsets of the public. Other crackdowns seem to be driven by legal motives, such as revolving door incentives or the desire to artificially shore up the public's the public's perception of the executive. Potential principal agent problems dog the crackdown choice. So the question then is, well, what is an honest enforcer to do? Can the law, can legal or societal institutions help to mitigate these principal agent problems? There's a simple governance question here. the question of how to reduce principal agent problems in the setting of enforcement policy, whilst also preserving the necessary leeway to enforce the law sensibly and wisely. So I argue in this paper that the faithfully part of the take care clause has bearing on this issue. So the clause requires that the President shall take care that the laws be faithfully executed. The executive branch is not merely required to take care that the laws be executed, but also to do so faithfully. The concept of faithfulness provides a unified standard against which we should evaluate the decision to crack down, whether that decision is made by prosecutors or by agencies, by the federal government or by the states, all of which incidentally have verbiage in their respective constitutions that parallels the take care clause. So, how should we understand this requirement of faithfulness? What does it incorporate for enforcement or for prospective enforcement policy setting? Well, to begin with, full enforcement is not necessarily faithful enforcement. As Maggie Lemos, among others, has recently argued, it may disserve rather than serve the interests of the public to maximally enforce every given law. Instead, I argue we should read the standard of faithfulness to create an obligation of honest interpretation on the enforcer. As the crackdown epitomizes, the act of choosing and structuring a conscious program of enforcement is fundamentally an act of interpretation. It is no less an interpretive act than the act of adjudication or the act of regulation. So why do I say this? Consider the simple example that I'm sure you've all encountered as 1Ls in year 1L here. The vehicles in the park hypothetical. So when a town cracks down on vehicles in the park, it's not just the judge who has to decide what should count as a vehicle. Well before the first summons issues, the mayor who set the crackdown's parameters has had to decide whether to direct the police to prevent people from bringing in strollers or tricycles. So in crafting that directive, the mayor must act as a faithful interpreter in translating the statutory command into an enforcement plan. This is a point that might seem so obvious, even banal, that its import might not be immediately apparent. But in fact, this idea has been notably absent in the arena of enforcement policy setting. There have been oceans of debate over the methodologies that should govern statutory interpretation by courts, but little attention has been paid to the anomalous island of simple literalism that persists in the context of setting enforcement policy. There is no polite way to put it. A plausibly available statutory hook exists for an enforcement program. Our law treats that program as valid. But I argue that the same considerations that shape interpretation elsewhere in the law bear on and must be brought to bear on this interpretive act, the interpretive act of the crackdown. An enforcer can begin with the statute's text, but the enforcer should not treat a bare textual license as sufficient to terminate the process of interpretation. Instead, the enforcer should also consider the overall statutory framework, constitutional values, and systemic commitments to rule of law values such as fair notice and procedural justice. What the standard of faithfulness enjoins us to do, in essence, is to abandon the literalist approach to enforcement policy in favor of a more expansive and pragmatic attitude that incorporates considerations of context, policy, and constitutional norms. There's also a second element to faithfulness that is just as important, as the Florida speeding crackdown and the Neil Salot crackdown made clear. Faithfully also means that the enforcer must abjure venal considerations in crafting the crackdown. So purely as an interpretive matter, reading a 25 miles per hour speed limit to require cars not to drive at 26 miles per hour is perfectly reasonable and defensible. But if the mayor decided to crack down in that way to, for example, enhance her chances of future employment at a firm that makes speed radar guns that the town has to then buy in bulk, or to keep a promise to a wealthy campaign donor who for some reason hates fast cars, then that strict enforcement regime would be unfaithful to the extent that this venal consideration had tainted the enforcer's decision. To take these two pieces together and put them in a nutshell, the enforcer must ensure that the crackdown is faithful, both as a matter of interpretation and as a matter of motivation. That standard of faithfulness. It's a standard that we should use to evaluate some of the crackdowns that the Trump administration is in the course of pursuing today. Again, the key thing to remember is that when the executive branch is deciding how to enforce its laws and regulations in categorical ways, what it is doing is interpreting the law. And like a court, the executive must strive to interpret the law in a way that respects the public interest, that respects constitutional and rule of law values, and that honors principles of fair dealing and justice. So let's consider the DACA rollback. So on September 5th of this year, just over a week ago, the Trump administration announced that it had rescinded the Obama administration's Deferred Action Program for Childhood Arrivals, the DACA program. The DACA program applied to people who had entered the United States before the age of 16. It provided those individuals with 3-year periods of deferred action and with work authorization. There are 800,000 individual beneficiaries of this program who could once again become eligible for deportation as early as March 2018. In announcing the shift, President Trump said that DACA created an unfair system that victimized millions of Americans. Attorney General Jeff Sessions said that DACA denied jobs to hundreds of thousands of Americans by allowing those same illegal aliens to take those jobs. Neither man offered any evidence for these claims. The worry now in immigrant communities is not just that DACA recipients will now be eligible for deportation. The worry is also that they will be targeted for deportation because, as part of applying for DACA, the beneficiaries of DACA identify themselves as undocumented to immigration authorities and hand over information to the federal government that will make them easier to locate, to detain, and then to deport. As Professor Leah Lichtman has written, the government coax these young people out of the shadows, deem them lawfully present, and then promise not to detain or deport them if they follow the rules. Some have argued that the due process argument here is so weighty that a court could enjoin the deportation of a DACA recipient. I wish that I was confident that the law went that far. But whether or not that reliance argument will ultimately persuade the court, the Take Care Clause means that these due process values, these due process considerations, should matter to the executive branch too. To my mind, there's no question that a crackdown on DACA recipients would be an unfaithful crackdown. It would be fundamentally unfair to use the information supplied by DACA recipients as a roadmap for a crackdown. A DACA crackdown would barter large impositions on constitutional values, values rooted in fairness, values shielded by the Due Process Clause, in exchange for slight or non-existent meal benefits. I do not think there's anyone who thinks that DACA recipients ought to be the top priority for immigration enforcement or even high on the list. The beneficiaries of DACA are not drug stealers or criminals. They were brought here as children, innocent in their own illegal entry into the country. And their participation in the American economy is broadly thought to make the economy more productive and healthier, not less. What this means is that if DACA recipients are the subject of a deportation crackdown come March, the explanation would be a political one, a venal effort by the Trump administration to shore up eroding approval ratings by pandering to his political base. It would be the deployment of enforcement resources, not in the manner dispassionate, reasonable, and just urged by Justice Jackson, but instead to drive up political support amongst those that placed Donald Trump into office. It would be an exercise of enforcement discretion, of enforcement power of a piece with the pardoning of Sheriff Arpaio, an act that can itself be interpreted as an effort by the White House to sanitize that sheriff's own unconstitutional, racially discriminatory series of crackdowns. All too often, the slogan of prosecutorial discretion is repeated as if it were an incantation that could justify any course of enforcement by criminal or civil authorities. But enforcement discretion, capacious though it may be, is not a blank check. As I have stressed, the branch where this will matter most is the executive branch itself. The crackdowns announced by a president have to be carried out by hundreds of federal prosecutors, by federal law enforcement agents, and by federal agency employees. These officials, no less than the president, are bound by the clause's injunction to faithful execution. And these officials, no less than the president, must ensure that their crackdowns are faithful, their actions are faithful, both as a matter of interpretation and motivation. We'll all be wondering about courts. what about courts? Do they have any role to play here? At the outset, I should say I do not think that existing black-letter law would permit the direct enforcement of faithfulness as a constitutional rule. That is to say, I do not think it is possible under existing law for a court to issue an injunction forbidding the mayor from cracking down on speeding because of a standalone claim by a ticketed driver that the crackdown is unfaithful. I do not think it is likely that a court will enjoin the federal immigration authorities from ramping up their enforcement of immigration laws on the standalone basis that such a crackdown violates the Take Care Clause. Heckler, standing doctrine, and other practical obstacles would impede or block such a challenge. And that is perhaps why the increasing number of lawsuits about DACA include Equal Protection, Administrative Procedure Act, and due process claims. They are not standalone Article 2 Take Care claims, of course. So what role for courts? I do think that courts can play a more indirect role. I do think that more indirect checks remain available here for judges to encourage more faithful crackdowns and discourage unfaithful ones. In this paper, I suggest a couple of methods for judges to work to help to protect this constitutional norm, a constitutional norm of faithfulness that would otherwise go drastically under-enforced. The core of the suggestion is to urge judges to more frequently and more openly challenge the executive branch's enforcement policy decisions, even though their hands are tied from directly blocking those choices. This kind of inter-branch dialogue can take many forms. For example, a judge might use her sentencing discretion to reduce the sentences borne by those who are convicted as a result of crackdowns that are unfaithful. A judge might, in oral argument, question the prosecutor about the executive branch's charging policy and charging choices for a certain class of cases. Exactly such questioning occurred recently at the Supreme Court during the Gates and Bond oral arguments, where some of the justices expressed skepticism and surprise at the DOJ's highly odd charging choices in certain criminal cases. I'm also thinking of a recent case from the Ninth Circuit, a deportation case involving an immigrant whose surname was Magana Ortiz. Although Ortiz had entered the country illegally, he had lived in the United States for 28 years. His wife and children were American citizens, and he was a businessman in Hawaii who would work closely with the United States government to help fight pests that destroyed coffee crops. After President Trump became president and started an immigration crackdown, Ortiz was ordered to report for removal. And the Ninth Circuit had to permit this deportation because Ortiz was undocumented. But Judge Stephen Reinhardt on the Ninth Circuit wrote an extraordinary concurrence in this case. He chastised the government for expelling a good man from the country in which he has lived for the past 28 years. The judge said that the deportation of Magana Ortiz would deprive his children of their right to be with their father, his wife of her right to be with her husband, and our country of a productive and responsible member of our community. The government, Reinhardt said, forces us to participate in ripping apart a family. He then addressed President Trump directly, saying President Trump has claimed that his immigration policies would target the bad hombres. The government's decision to remove Ortiz shows that even the good hombres are not safe. He concluded by saying that the removal was contrary to the values of this nation and its legal system, and that deporting Magana Ortiz diminishes not only our country but our courts, which are supposedly dedicated to the pursuit of justice. He said that the judges forced to participate, who are forced to participate in such inhumane acts, suffer a loss of dignity and humanity. He ended by saying, "I concur as a judge, but as a citizen, I do not." It is this sort of judicial commentating that Judge Reinhardt is not the only example of. The more, I suppose, mundane example of SEC enforcement. Judge Rakoff has also written about critical remarks about various crackdowns. And these types of writings, he's also written about criminal law, but administrative law too. And I think these types of judicial statements have arguably acted as an impetus for the DOJ to reform its stated policies on bringing charges in the past or entering into settlements. And it is not outside the bounds of possibility that they may have some influence now even now that the presidential administration has changed over. Institutions don't only respond to hard commands, they change as a result of soft pressure too, and Professor Fleming's presentation showed how sometimes judicial action in a particular private law context was able to prompt responsive legislative change. By engaging in commentary like this, judges can exert soft pressure on enforcement indiscretion and incentivize better decision-making by prosecutors and agencies up and down the line. I acknowledge, some are highly uneasy with this kind of judicial commentating, this kind of extracurricular judicial remark. They think of it as unseemly. I look at it differently. Such public commentary by judges, in my view, is not so different from a series of pointed questions at oral argument, or from a fervent dissent, or from a fervent concurrence. These are all substitutable discretionary devices through which learned observers, here federal judges, can push to augment the quality of enforcement policy, even though they remain formally forbidden from directly intervening in this zone of executive choice. Just as ambition must be made to counteract ambition, so must judicial discretion be made to counteract executive discretion. That's all I have to say. Thank you.
I'd like to open it up to questions for Professor Sahoni. Yes, Professor Goldfarb.
I wonder if you think that Judge Reinhardt's hands were in fact tied, or the judges in that situation, because it does seem that the theory that you've developed could serve to untie their hands to the extent that motivation matters, to the extent that notice and due process and equal protection matter, to the extent that Article 2 clause should incorporate these other values. So is it in fact the case that all they can do is comment?
So I think that in that particular case, these other arguments hadn't been, like other arguments that were constitutional in nature hadn't been developed. I don't think that there was a factual basis in that case on which you could have said, there's an equal protection violation here or a due process violation here. We will now see whether these kinds of substantive enforcement discretion attacks can gain traction. The deck is, it should be said, the deck is stacked in the government's favor. Getting discovery, getting the basis of these kinds of enforcement policy choices will be difficult, and it may turn on judges' willingness to consider public statements and tweets by decision makers, press conferences, and other contexts. A lot of this stuff is very untested.
And then if I could follow up, just how does it apply in the case of forbearance, where the Obama administration's policy is choosing not to? The argument by the opposition is that was not faithful execution of the law. So how does the theory play out in that context?
So I think the argument was, I think, of the opposition. So people have said it's unconstitutional for the government to prospectively not enforce the law, and the argument was that that's not taking care that the laws be executed. I think my response would be, well, if the take care clause analysis is the right one, but the question is was that a faithful understanding of the statutory scheme? And they were trying to target enforcement resources to the worst offenders, and the question would be whether or not the granting of work authorization on the light end, whether that would constitute faithful execution. So this is the same analysis that would apply in both contexts.
Are there other questions? We appreciate very much the timely, also the topic of this as well. Thank you very much.
Thank you.
Our next speaker is Professor Veltri, who is here from the University of Ohio Northern University, where you were twice interned dean at the College of Law. You teach commercial, have taught commercial law for 30 years, and there is prudence you say from time to time.
Yeah.
And today is one of those times. Of course.
I want to thank everybody at New England Law for the invitation to be here today. It's been a great pleasure. And we've been really so well arranged and involving such gracious hosts. Appreciate it. I particularly want to thank Professor Gary Hansroot for thinking of me when he was putting this panel together. When he called me, he said I wouldn't have to worry about having a paper ready for the symposium. As all of you know who have ever put any of these panels together, that's terrific salesmanship. And so I'm the one that gets the chance to have my remarks gone over by you all before I put them to paper in great length. And that's always great. It's always great to know people think your ideas are all right before you waste a lot of time putting them on paper. It was illuminating for me to read Professor Nyquist's paper. It crystallized for me one of the principal differences between the adherents of sociological jurisprudence and legal realism was their respective views of the value of adjudication as a social ordering mechanism. As Professor Nyquist points out, adherents of both schools criticized the classical legal tradition, which purported, of course, to derive a rule from leading cases and then through a process of deduction, and that judges and lawyers could then determine the correct result in subsequent cases by a process of deduction from that. To the proponents of a sociological jurisprudence, this method, which was ultimately grounded in adjudication, could seldom, if ever, come up with the best rule to achieve the optimal social end or aim, which Professor Nyquist calls the teleological balance. Consequently, Pound, Brandeis, and the others who shared their line of thinking thought long and hard about how to either sidestep or fix adjudication as a lawmaking process. The realists, on the other hand, they were critics of the classical legal tradition primarily because they were such rule skeptics. They were skeptics of rules of any sort, no matter how they were derived. They thought about law at a much more granular level. How do the people actually resolve disputes? How do merchants actually treat their transactions on day-to-day business? The realists thought of this as a multifaceted investigation, very, very fact-centered, properly understood to be elusive, undertaken in the light of evolving customary standards, which they felt could be observed. Their paradigm was something like how I understand Professor Nyquist's description of a balance of competing considerations. And if this is how you think of law, adjudication, at least if it's done right, isn't a bad social ordering mechanism. So what I hope to do today is first describe how the principal American philosophers of law in the first half of the 20th century viewed adjudication. In a nutshell, Pound, Brandeis, and the other advocates of a sociological jurisprudence tended to focus on its shortcomings. The realists, on the other hand, and I'm speaking here particularly of Llewellyn, tended to focus on its strengths. Once I've done that, I'm going to turn to the second task, which Professor Hansroot asked me to undertake today, to address how the philosophy of law might shed light on contemporary problems in my field. I found that task to be particularly interesting because I teach negotiable instruments, bills and notes, a field of law that is nearly completely untouched by 20th century jurisprudence. And so perhaps for that reason, both sociological jurisprudence and legal realism offer useful critical perspectives on how negotiable instruments law is being made today. What I hope to do is show how each of these schools' view of adjudication shaped how they would do statutory interpretation. I don't think either school would be too happy with how the courts have interpreted one section of the Uniform Commercial Code since its revision in 1990, and I think Gary passed along a handout which I'll use. I could use one of those here. Thanks. For Roscoe Pound's first writings, where he coined the term sociological jurisprudence, it was his last, his view of what the law should be remained unchanged. In an article he wrote as a young man, The Scope and Purpose of the Sociological Jurisprudence, he extolled the virtues of von Ehren's thought that law developed from competition among social groups to further their interests, and that the law to harmonize those interests to achieve the greatest social good. This view is just remarkably consistent with, I think, the marvelous quote in your paper that he wrote over 30 years later. And I loved it because it was such a run-on sentence. Those of you who study philosophy remind me of Hegel. Such an outline are the social interests which are recognized and are coming to be recognized in modern law. Looked at functionally, the law's attempt to satisfy, to reconcile, to harmonize, to adjust these overlapping and often conflicting claims and demands, either through securing them directly or immediately, or through securing certain individual interests, or through delimitations or compromises of individual interests, so as to give effect to the greatest total interests, or to the interests that weigh most in our civilization, with the least sacrifice of the scheme of interests as a whole. If this is your aim, I think adjudication is probably a pretty poor instrument to achieve it. By its nature, adjudication is sharply party-directed and focused. We can be reasonably confident in both trials and appeals that the court has the views of the parties. We must have doubts, given the process, that the court will hear the point of view of either individuals or groups who may be affected by the cases. Pound and his contemporaries were acutely aware of this problem. Speaking of the transition to an improved body of modern law, Pound wrote, and I quote, "The courts then may not in reason be asked to lead in the present transition. It is no ill sign that economists and sociologists are ahead of the law, provided the law knows it." Close quote. The quote highlights what Pound perceived as a shortcoming of adjudication. Courts, the adversary process, the rules of evidence are reasonably well suited for finding historic facts. You know, was it raining on the night in question? Did the defendant act with malice aforethought? Was he driving too fast? They don't handle scientific evidence or make predictions. So, in other words, they're not good agencies for finding what often called social fact. And aware of these shortcomings of adjudication, Pound and the other advocates of the sociological jurisprudence tried to address them in a number of ways. First, they thought that legislatures and administrative bodies were just better agencies than the courts for taking stock of the views of economists, sociologists, and competing social groups and forces. Again, going back to that first article praising von Ehring, Pound advocated for legislative solutions to social problems. As he put it, quote, "To one who thinks of society as recognizing interests and creating rights to secure them, law is very likely to be something made rather than found," end quote. In other words, the process had to be more legislative than adjudicative. By their nature, legislatures, in Pound's view, were better agencies than the courts for hearing from a wide array of social groups in making law. The process is party-directed. Through hearings, legislature can canvass the view of disinterested experts, not rely only on hired guns, hired by litigants. Pound's most forceful critique of the classic legal tradition makes these points. His article entitled "Liberty of Contract" assailed the judicial decisions of his era that struck down legislation aimed at regulating wages, hours, safety, and workplace. The party-centeredness of adjudication, in Pound's view, quote, "exaggerates the importance of property and of contract, exaggerates private right at the expense of public right, and is hostile to legislation," end quote. Faced with the constitutional challenge to workplace regulation, Pound lamented that, quote, "the court has no machinery for getting at the facts," end quote. "It must decide on the basis of matters of general knowledge and accepted principles of uniform application," still quoting. "It cannot have the advantage of legislative reference bureaus or hearings before committee, of the testimony of specialists who have conducted detailed investigations as the legislature can and does. The court is left to deal with problems artificially," and by which Pound meant, of course, the method of classical. Brandeis, the other one of the sociological jurisprudence that Curtis mentions, preference for the legislative process over adjudication is nicely illustrated by one of the cases in the first year curriculum. The case is in the property code usually, and it involves the dispute between the Associated Press and INS. In World War I, the Hearst papers were strongly opposed to the entry of America into the war. And so consequently, the British and the French banned the Hearst News Service, INS, from using the transatlantic cable. So that, as a practical matter, prevented the Hearst papers from timely reporting any news. What made matters worse was that the British and French continued to allow the competing news service, AP, the Associated Press, to use the cable. So faced with this competitive disadvantage, the INS began lifting the facts related in AP news stories for Hearst newspaper accounts. In some markets, that enabled INS to break a story first, even though they had lifted the facts from an AP story. This could happen, for example, if the Hearst paper was the leading paper in a market where the AP paper was the evening paper. So the AP sued INS to enjoin it from publishing news that it came from an AP story, and AP won the case. The Supreme Court of the United States reasoned that the INS should not be able to reap what it didn't sow. The court therefore found that AP had a quasi-property right to news for a temporary period of time to prevent INS from gaining an unfair competitive advantage. In that case, Brandeis penned one of his most forceful dissenting opinions. He would have given the AP no relief at all, and he would have left the problem to Congress. He was concerned that the injunction would hamper the public interest in having the news quickly. The sharp focus of adjudication, he wrote, made it unlikely this interest would be given proper weight. He wrote, where the problem, quote, is relatively simple, as it is apt to be when private interests only are involved, adjudication generally proves adequate. But with the increasing complexity of society, the public interest tends to become omnipresent, and the problems presented by new demands for justice cease to be simple. Then, the creation or recognition by the courts of a new private right may work serious injury to the general public, unless the boundaries of the right are definitely established and wisely guarded. It is largely for this reason that in the effort to meet the many new demands for justice incident in a rapidly changing civilization, resort to legislation has lately been had with existing frequency. The judges and scholars associated with sociological jurisprudence did not simply try to sidestep adjudication, moving it to the other lawmaking agencies. They sought to improve adjudication. I think Professor Nyquist mentions a couple of those that are very good examples. Brandeis, for example, is associated with the Brandeis Brief. It's easy to forget how radical the Brandeis Brief really was. You gave the numbers earlier, Curtis. Two pages of law. How many pages of sociological data?
111.
111. Like, as someone who tried cases in my younger days, I can tell you, as far as I'm concerned, that's 111 pages of uncross-examined expert testimony. I mean, that's not adjudication. And the more radical proposal, which you also mentioned in your paper, both Cardozo and Pound thought there should be a Ministry of Justice. They actually thought there should be a non-party giving input to the courts, the appellate courts, when they decided cases, and would let them have the benefit of social research, medical experts, and other parties. The proposals of Pound, Cardozo, and Brandeis to improve adjudication are quite understandable, I think, when you remember what they were after. They wanted to find a standard for judicial decision that properly balanced all social interests. I think they were after what Professor Nyquist's paper well describes as a teleological balance. That's what they wanted. The realist critique of all that was that those guys were still thinking of law as a brooding omnipresence in the sky. The realist, sociological jurisprudence, was still looking for a rule. A rule more responsibly derived, perhaps, but a rule nonetheless. The realists were thoroughgoing rule skeptics, and they wanted to bring the study and understanding of law down to earth. They were not interested in what they called law in books, but rather law in action, and they got very, very granular about it. What they liked to do was drill down to the facts of what Llewellyn called a, quote, situation type, and then show how the courts really resolved disputes. It had nothing to do with rules or legal doctrine. Instead, courts, particularly if they were in the hands of good judges, used their, quote, felt sense of decency and what Llewellyn called, quote, situation sense to reach a just result. Llewellyn studied in Germany, and he picked up the habit of making compound nouns, which has since driven everyone crazy reading his stuff. But if you look at the work of the realists, it's quite evident that what I've just described are the essential features of them. For an example of their predilection to get down to the financial minutiae of situation types, look at Underhill Moore's detailed observation of how folks in New Haven behave toward parking regulations. For an example of how the realists saw the organizing principle of the law in situation types rather than legal doctrine, look at the torts book that Leon Green put together during the heyday of legal realism. The chapter headings in his torts book are not doctrinal, not intentional torts, not assault, battery, negligence, strict liability. The headings are all situation types. Surgical operations, keeping of animals, traffic and transportation, power, telephone, and telegraph companies, and so on. The case book is nearly 2,000 pages long, and it's organized entirely by the factual settings of the disputes. In other words, situation types, not legal rules or concepts. For an example of the realist fondness for demonstrating that the doctrines of classical legal theory did not explain the actual results of concrete cases, look at Herman Oliphant's article on covenants not to compete. The article looks at lots and lots of cases and shows, quite convincingly, that contrary to what classical legal theory would hold, the courts treat a covenant not to compete quite differently, given the situation type. Courts tend to enforce covenants not to compete in agreements for the sale of a business. That is, when the seller agrees not to compete with the buyer after he's sold the business at the closing. But they treat them much more warily when it's in a employment agreement. Another example, Llewellyn looked at the rule of sales that says if a buyer formally objects to deficiencies in a seller's shipment, the buyer waives any objection that's not specifically mentioned. Llewellyn showed that the courts apply this rule with a vengeance when it appears that the buyer is trying to back out of a contract for reasons unrelated to the objection. The courts, on the other hand, ignore the rule when the seller is seeking to enforce it against a buyer who did not know of a deficiency in the seller's performance when he made his formal objections. Again, judges, at least good judges, do not apply formal rules to decide cases. Rather, they seek to do justice in situation types. And given the way the realists thought of the law, it's not surprising that they look far more favorably, I think, on adjudication as a social ordering mechanism than did the adherents of sociological jurisprudence. Courts are pretty good agencies for looking at historic facts. What were the deficiencies in the seller's shipment? Did the buyer object? Did the buyer know of the shortcomings in performance to which no objection was raised? Does the buyer have an ulterior reason, like falling prices, to want out of the bargain, and so forth? The courts, in other words, are good vehicles for balancing competing considerations, to use your phrase. I think the types of balancing you mentioned on page 57 are different because they're done at different levels. The level of the sociological jurisprudence is done at the social level. But the second picture of the competing considerations, I think, is done really at the level of very granular facts and cases. The realists, and again I'm speaking particularly of Llewellyn, carried their rule skepticism over to legislation. To Llewellyn, even the most honest dispute over the meaning of a statute should be resolved by a court first deriving a principle from the legislation's purpose. Then the court should, with a strong situation sense, determine how that principle would best be served given the facts at hand. The article that was mentioned earlier, he advised law students and lawyers that any simple, tenable construction of statutory language can be solved in this way. Situation sense clearly mattered more than the canons of construction, which he showed in classic realist status are completely indeterminate. Right? That's classic legal realist scholarship. He looked at lots of cases and showed that every canon leading to one result could be matched with a canon leading to the opposite. That's what they like to do. Llewellyn tried to build a fact-centered approach like this into the Uniform Commercial Code. In appropriate situations, he wanted the courts to look at customs and trade usages rather than formal legal rules. He wanted to interpret contracts in light of the parties' previous dealings and opportunities for performance. Above all, he embedded in the code some open textured standards that would enable the courts to do justice in given situation types without the need for manipulating formal rules. So, for example, he would have the courts find a harsh bargain to be unconscionable, rather than have them twist the rules of offer and acceptance to avoid enforcing the bargain as a contract. Notably, Article 2 directs the courts to look at facts, the commercial setting, purpose, and effect of a contract in order to decide whether it's unconscionable, not theory, not the traditional equitable notion of conscionability, the old case. Similarly, Llewellyn wanted the parties' good faith to always be relevant in deciding disputes over contracts. Again, he defined good faith to require judicial inquiry into facts and customs. Good faith is defined as honesty in fact in the inquiry and the observance of reasonable commercial standards of fair dealing. Llewellyn believed that as the courts applied these open textured phrases in given fact situations, the law would become more reckonable than it would if the courts were instead manipulating rules to achieve the just result. Over time, the meaning of the standards would become more clear as they were employed to decide concrete cases. In addition, the standards could evolve. Llewellyn was a great advocate of the common law tradition, and he lionized judges like Lord Mansfield. When the great judges Llewellyn admired wrote honest opinions explaining why they were deciding a case, they gave both a measure of predictability and flexibility to the law that adherence to formal rules could not possibly achieve. No wonder Llewellyn called their methods the grand style in his book, The Common Law Tradition. What I'd like to do in my remaining time is describe how legal realism and sociological jurisprudence might offer a critical perspective on how the courts are reading one section of the Uniform Commercial Code today, and that's the one I distributed. The section is 4406, and it's commonly called the bank statement rule. Under that section, if a bank makes a statement of account available to its customer, the customer must examine the statement with reasonable care, reasonably promptly. If the customer fails to do so, there can be adverse consequences. Most notably, the Code's standard rules for allocating losses due to forgeries and alterations won't apply. Ordinarily, if someone would forge your name on one of your checks, you're not liable if the bank pays it. Similarly, if someone raises the amount of one of the checks you wrote, you won't be liable for any sum greater, generally, than the amount you originally wrote. Section 4406F in the existing statute is the lower one on the front page, the one that says as amended in 1990, changes that result. If you don't notify your bank of a forged check or an altered item within 1 year of when your bank first made available to you a statement of account showing the bank paid the forged or altered check. This notice of claim provision, the last subsection of 4406, does not require the customer to sue the bank within a year. It simply requires that the customer notify the bank within a year, which is commonly sometimes called a statute of repose, not a statute of limitation. Section 4406, as you can see, has been in the code since it was first promulgated. In 1990, the section was revised, and everybody's focus was principally on one aspect of it. If you look at the original language of 4406, and that's the one at the top of that handout, in 4406.1, you can see that the banks used to be required by law to return to their customers the canceled checks that were written on the account each month. You used to get a stack of canceled checks with your bank statement each month. Well, that's quite expensive for banks to return checks each month. And so the drafters wanted to eliminate that expense. It was an unnecessary transaction. So they redrafted one. And when they did so, they took out the language that when a bank sends its customer a statement of account accompanied by items paid in good faith, they kind of left that out. And they drafted what you see in A, and their focus being to make sure banks don't have to return canceled checks. This change has led the courts on quite a series of cases. What's happened that the courts have now read this change of the first subsection of 4406 into the last subsection, the 1 year notice of claim provision. If you notice from the handout, 4406F, the last provision, relates exactly to what had been 4464. The provision never had a good faith in there. Never was in there. But the courts, prior to its revision in 1990, always read the good faith language from subsection 1 into 4. The bank had to act in good faith in order to take advantage of the notice of claim provision. The courts, however, have now held, since the language isn't in F anymore, there is no obligation of the bank to act in good faith for it to take advantage of that same provision. If a customer doesn't notify his or her bank within a year of a statement showing a forgery or alteration, the bank's off the hook under these decisions, even if the bank's acting in bad faith. Under the holdings of these cases, frankly, and there are about at least half a dozen of them, Steve, I think at least, even if the forger had an accomplice at the bank, it really wouldn't matter. Under the 1990 change in section 446, the bank can escape any liability for forgery. I was around for a fair amount of the discussion over the 1990 revision. I think Curtis was there too. And I can honestly say with some confidence that the changes made to 446 were never intended to work this result. That was just no one's thought that that's what was happening. As I mentioned, the revision was largely intended to eliminate the need for banks to return canceled checks. Article 1 of the code still says, and that's on the reverse side of it, as it did when Llewellyn first wrote it, that all contracts under the code, including bank deposit agreements, must be performed in good faith. The courts have ignored that general provision in their very cribbed reading of section 4406F. Llewellyn, of course, would have been aghast at this. Reading the text of a rule without any consideration of its purpose is not how he would have statutory interpretation done. Not recognizing the role of good faith in reaching the right result would have been far, far worse to him. Because in the situation type, contract performance of a deposit agreement, good faith would have been his animating principle. He wanted to decide things that way. Another line of cases interpreting 446F is, in my view, even more troubling. Dozens of cases now have allowed banks to shorten the 1-year notice of claim provision in their deposit agreements. In most deposit agreements today, the period's probably 30 days, not a year. If you go home and look at yours, my guess is relatively few of them are going to be longer than 30 days. The Court of Appeals in New York recently upheld 14 days in a business deposit agreement. So in other words, what the statute had said at 1 year is 14 days for a business in New York. And some shorter periods for consumers, probably 30, I think. And of course, those of you who remember your course on bills and notes, negotiable instruments, will recall that a great deal of the course is devoted to elaborate rules in Article 3 and 4, allocating losses resulting from forgeries and alterations. I mean, that's the bulk of the course. I'll spare you the details, but there are many sections of the code devoted to loss allocation, and they make an effort to strike a balance among depositors, banks, and payees. The rules are designed to make sure depositors verify the identity of the persons they're writing checks to. They require the depositors to monitor their employees who have authority in handling checks for them. They require them to inspect their bank statements. But at the same time, those rules also are designed to assure banks act with due care in taking checks for deposit, that they be particularly careful when they're dealing with fiduciaries, and so forth. The loss allocation rules attempt to protect the finality of payments made to payees as well. In other words, if you look at those rules, they attempt to strike a balance among the interests of everyone involved in the checking system. Obviously, I think, all of these rules go out the window if a deposit agreement shortens the notice of claim provision to 30 days. None of the other loss allocation rules will matter. Faced with losses resulting from check fraud scheme, a bank will gladly recredit its customer's account for the first 30 days of fraud losses if the bank's off the hook for the rest. If you look at every one of the cases that has upheld a shortened notice of claim provision, and there are now well over a dozen, the customer loses. Many of them, I think most of them, would have gone the other way if the code's standard rules for allocation of loss had applied. Now, if you look at these cases, I think they would have driven Roscoe Pound crazy. These decisions, in the name of freedom of contract, upend a balance struck by legislation. Remember, the contract here is one of those funny kinds. The 12 pages of fine print that dropped out of the envelope when you opened your last mail statement. Or more likely today, the pages and pages of the computer screen you had to advance through and click accept before you could look at your bank balance. That's what kind of a contract would do. The legislation, on the other hand, the process of the National Conference of Commissioners of Uniform State Laws and the ALI was a process Pound rather admired. I mean, I know that there have been in recent years some complaints about the process from consumer interests and others, but the process certainly makes an effort to make sure all interested parties have a say in the process. I mean, it does that quite deliberately. And, that's what we're looking at. You're having a balance struck by that process being upended by a private agreement, quote unquote. I'm not saying that the balance struck by the current code in 1990 is ideal. I think it's certainly outdated. All payments law is about secure communications. For the last 500 years, communications about what to do with a bank balance. And it's a shame, but true. The last revision to Article 3 and 4 took place on the eve of the greatest revolution in communications in human history, and that the rules don't reflect it. The drafters were thinking of paper, couriers, and snail mail, not the internet, digitized images, and all the rest. My point here today is, notwithstanding these shortcomings, neither the legal realists nor the proponents of a sociological jurisprudence would have been happy with how the courts have treated Section 446. The courts are not looking for the purpose of the one-year notice of claim provision and seeking, as Pound would, to preserve the balance of interest struck by the section. They're instead, to the delight of bankers' lawyers, exalting contract over the balance struck by public law. The courts are also not seeking, as Llewellyn would, to achieve the purpose of the notice of claim provision at a granular level, looking at the facts of a given dispute, and with a strong situation sense, recognizing the duty of good faith, trying to reach a just result. Instead, with a kind of textualism Llewellyn would have abhorred, they've read good faith out of the section. Well, why is this? I mean, that's the question that I ask. And I have to say, frankly, lawyers today, judges today, even most law professors today, are neither devotees of a sociological jurisprudence or legal realism. Llewellyn always believed that judicial decisions reflect what he called a period style. And what he meant by that, yet another compound noun, was that decisions, particularly the appellate courts, display in any given era a similar style. He wrote, for example, of how the era of Mansfield, Marshall, Kent, which he called, as I've mentioned, the grand style, morphed into something a generation or so later he called the formal style. Grant Gilmore's Storrs lecture, The Ages of American Law, has a similar theme. Llewellyn used to challenge his students to go into the law library, pick a couple of shelves of reporters covering a few decades, and just pick cases at random. And he said, read those decisions and describe the period style they display. He thought you could do it. And, well, I think I've, engaged in that exercise over the 3.5 decades I've practiced law in the field of Goshen Moonstones. And so I'll let you know what I think are two key features of our current period style. First, I think there arose in the late 1970s and early 1980s a concern that constitutional law was becoming completely non-interpretive enterprise, not tied to any text. And as a result, there was a reaction to that. that came up with a new attachment to textualism. And that has migrated from constitutional law to statutory interpretation. And then second, with the advent of law and economics, appreciation grew for private ordering through bargain for exchanges rather than public ordering through legislation. I think earlier today talked about informalism, and I think that's part of that. The way courts have treated Section 4406 over the past 2 decades reflect these features of the current period style. The words good faith are not in subsection 4406F. Under the hypertextualism of the current period style, the courts will say, well, we don't care if the drafters of the code left that out inadvertently. The words good faith, it's not our job as judges to read them back in if the legislature didn't put them in. You actually read opinions instead. It's not our job to help the legislature fix a bad statute. The courts today do not engage in the kind of close examination of facts of a dispute in light of an open textured concept like good faith. Steve and I were talking about that earlier. They're not looking to find things, doing a fact-centered analysis of a conscionable contract. They don't want to do it. In the current period style, that kind of balancing, according, leads to ad hoc results. That's the criticism, ad hoc. That balancing of competing considerations is no law at all. It's just not giving you and it gives you an undesirable degree of uncertainty. Rule skepticism simply isn't in vogue today. As for the one-year notice of claim provision, critics say that it's far too long in the information age, and I tend to agree with that. And they claim that private agreement in the market are operating to give us a more efficient allocation of the risk of loss than that one-year claim. That's the claim of bankers. The problem is that I'm not sure the bank agreements today are any more balanced than the employment agreements were in the Lochner era that Pound criticized. I mean, they're kind of one-sided things. And I think for that reason, Pound would have been aghast at what we're doing with this section today. So that's my take on what sociological jurisprudence tried to do, and the realists, and also on today's period style. I'd be very interested to hear from anyone of how they think the current period style is working in your fields, and that's it. Thanks very much.
Well, I think, again, as an apologist for the Uniform Law Division, we try to vet these things, and that's actually the reason why I spend time doing it.
Yes.
Compared to what Congress does.
Yes, that's right.
However, we're in essence a federalist organization.
Right.
So we're trying to do stuff harmonized between the states, where instead of like feds do everything.
Right.
Of course, that has a bad name today because people think states' rights means slavery.
Yeah.
That's what generally people think. But the danger that I mentioned is actually similar to what I said earlier. Isn't the Federal Arbitration Act, which preempts almost everything,
right,
really wipe out most any kinds of limits?
Yeah. I mean, that's another example, I think, of the current period stuff.
Right.
When I first came to the bar, in our firm, I represented a lot of brokers. When I came to the bar, if you sued a broker for a violation of the federal securities laws, it was not arbitrable. It didn't matter what your agreement said. The court said that the securities laws of the United States struck a balance of public policy that can't be upset by a private ordering mechanism. And they didn't enforce them. Well, that's not today's period style. I mean, they changed that rule, a Supreme Court decision, I think that was around the mid-'80s.
Concepcion also, right?
Yeah. And so, I mean, that's another example of how, we've gone from looking at a balance struck by public legislation to being comfortable with private ordering. Yes?
So The problem you're describing is similar to what happens with credit cards. If I make a purchase, I've had calls from credit card companies that call and say, is this fraud? Because it doesn't match my data pattern.
Right.
I think the same thing is true with what you're describing, that banks have the capability of detecting fraud through data analysis and could prevent that. And so it sounds like the lack of legislation, the lack of a law, sort of motivating them to do that is
Yeah, I think clearly in the case of your credit card, the law does motivate them to do that because they make the bank liable. The law, beyond a very minimal amount, $50, an unauthorized use of your credit card is on the payment systems, on the banks. So they have invested tons of money in fraud detection. And it does work the way you described. With your checking account, it always was more favorable to the banks. But if you have now made the law where they don't have to, they're not liable unless you tell them within 30 days, it reduces their incentive to do that kind of policing, I think.
So maybe it's an opportunity for a company who wants to distinguish their level of service, especially somebody who offers, like for example, online checking and national, to say, you know, the law is we don't have to cover this, but we do.
Right. Yeah, I mean, that assumes, I mean, you know, our conversation right now is, to me, demonstrating the current period style. We talk about economics and private ordering and the market will fix. But, you know, your question presupposes that consumers are informed enough and there aren't real difficult economic issues with actually the market reflecting the consumer choice. I think most of you probably haven't really read your deposit agreement, know what's in there. You certainly didn't open your bank account on the basis of it. And so there's a whole host of problems with that model. But the fact that we're talking about it, that's how we talk about law today, you know. Yeah. Either one.
To get back to the law, the theory in the law school curriculum, isn't there one case book today that's still based on Llewellyn's transaction types, the Wisconsin contracts book?
Yeah, I don't know that that's still out there anymore.
We had one of the co-authors of one of Gary's conferences a few years ago, Gene Browker. I meant to ask her whether anybody's using the book.
You know, I mean, that's a great question, because if you look at the case books, you can really see what sociological jurisprudence, what legal realism is about. I mentioned Leon Green's case book.
Yeah. That rings a bell with this other book.
Yeah, my favorite case book for sociological jurisprudence was written by one of our grads. He was the reporter for the first restatement of torts, and it was at Indiana. Then he went to Yale after World War II, and he wrote with Harper James the torts thing. But when he went to Yale, he was although it was the 1950s, he was of the older school sociological jurisprudence. He was a protege of Goring or somebody like that. So he wrote a case book. He was assigned to teach family law. His case book on family law has about like a third cases, and 2/3 Kinsey, you know, sociological data. And you know, he was the guy who you know, persuaded Estelle Griswold to challenge the Connecticut stuff. So I mean, you know, in a conference where we're talking about the role of theory and having an effect on law, that's a pretty good example. You look at his case book, though, it's sociological jurisprudence. It's like a Brandeis brief of case books. Very little law, lots of sociological data. Question?
Yeah, I think this period style you were talking about has to do with control, right? The banks leave out these certain statements. They don't abide by the old law because of control, right? And all of this is driven by media, right?
I think the current period style allows the bank to change the rules by contract in a way, I think...
To control the people.
Yeah.
Exactly, right?
Yeah.
Yeah, okay, and I have a couple things to say, actually, about this. I think that the realist, that granular definition they were trying to find, was maybe, it could have been defined as something like this. Amongst two competing hypotheses, right? The one with the least assumptions should prevail, right?
Yeah.
And the magistrate that Brandeis was referring to the judges, right? They should be more impartial and maybe abide by natural law, right? Maybe?
I'm not sure the realist would have been there.
No?
No.
No,
And I do think that they thought if a judge had and Llewellyn used very ordinary words. He would say a felt sense of decency. The judge looking at the facts, multiple facts, balancing them, all over, with a felt sense of decency would come up with the right result.
So the
He was a
situation,
good person.
okay. The situational sense essentially is like an understanding people.
Yeah, it's real facts. It's very facts.
It's very interesting.
It's great.
Thank you very much.
Thank you.
Just going to put up a PowerPoint. We're going to try to wrap it up in a little bit of an orthodox way, which, from my perspective, actually, there's not going to be much. And I'd like to invite Professor Nyquist to come back to the table and say, it's really, it's not much.
Lisa, where should I be?
Have a seat. So our idea was, and I think one of the challenges of this conference, and it's a wonderful challenge, is having individuals here who are at so many different levels of relationship with the concept of theory. Some of us, may be comfortable with it, others are getting comfortable. There are law students, there are law professors, there are law professors who are doing different areas of practice. And so what I was thinking would be helpful is to kind of try to tie it all together and to do it in a way where we're also making it complicated by weaving in some wonderful expertise by Professor Nicola, who teaches in the area of comparative law and is joining us to answer some of the questions that we're going to pose. Just by way of background, I am a skills professor, and what that means is I basically work in the trenches with law students on basic skills. Do you remember IRACing? That is issue, rule, application, conclusion, how to brief a case, how to find a rule. We just started talking about law school exams. We're really kind of results oriented, and at the law school here, that's what I'm focused on. And so when Professor Monser approached me and said, let's work together on this theory conference, I was really intrigued, but I was a little bit skeptical, I think, because I do work with students on basic skills, and I think that depending on the law school that you're at, depending on the student that you're working with, you're taking people at different levels, and we're trying to give them an education that's practical, as the dean said when he started the remarks this morning, but then also that allows them to rise to the level that they are able to rise to. And so I'm really coming at this from an educator's perspective, and so I wanted to remind us, and I didn't know how many of my students would still be here. I see a handful. There was a whole bunch of them. I persuaded them. I told them there'd be food, which you would get students in the room. I said, just stay, because you're going to get something out of this. And even during the break, I'm trying to explain to them, what are they going to get out of this? Well, they're going to get sort of exposure, I suppose, at a very high level, exposure to really smart people, really complicated, interesting ideas, and this idea of theory, which at this point for many of us, many sort of law students, it's just an idea they want to get comfortable with. And so I did think that we could come back to, Professor Monster and I put a lot of thought into the conference documents in which we raised questions, also working with Professor Nyquist. What are the questions that we wanted to answer? And kind of in my learning objectives style of teaching, I'll always tell my students, these are my objectives, and then did we meet our objectives? And so just to kind of call us to task, we're going to talk about some of the questions that we raised in our conference documents, the reasons why I think at least the students who were here earlier and many of you are here are to hear some answers to those questions. I assume, I hope. So, no, that did not work. I have the worst luck with technology. There we go. Okay. So our conference documents define legal theory as a lens to engage in systemic thinking, and Professor Fleming mentioned this earlier, a lens to engage in systemic thinking, not only about how the law currently works, but as part of a values-driven inquiry into how the law should work. And we said quite provocatively, that consideration of these questions can invite deliberation about values that should drive changes in the law. I thought that would bring people in the door. Objectives that may be achieved through the law, and then concrete ways in which theory can be integrated into advocacy, counseling, and judging, as well as teaching. So a lot of the speakers today have spoken directly to theory, named theories, talked about theories, realism, progressivism, classical legal thought. Others have spoken more obliquely to it to kind of talk about theory in the background of real-life situations. But I wanted to kind of call us all together in a way that we can answer some of our questions. So our questions were threefold. Basically, we distilled them down, and Professor Nicole and I worked together a little bit in trying to identify what were the core questions that people are going to want to leave this room with the beginnings of answers to. The first question is there a place for theory in the law school classroom? And if so, how do you bring it into your classroom? I'm struck by the presumptive answer, of course there's a place for theory in the classroom, right? It seems to be this, and I feel like I would be a little bit of a contrarian if I said, maybe there is, maybe there isn't, but can we make that a real question? And if so, how are we actually going to bring it into the classroom in a practical way, given what our students are here to learn and given what we're here to teach? Is legal theory even relevant to practitioners struggling to represent or advise clients? Certainly, depending on your practice area, the type of client they have, the resources they have, your bandwidth in terms of your caseload. That's a question where, I mean, I know in my years in practice, I wasn't thinking explicitly about theory, even though I was working at a big firm in New York City representing clients with very deep pockets. I was thinking about take the law, write a great brief, and hopefully win. Half the time I did. How does your understanding of maybe not? Thank you. So, and then how does your understanding of legal theory shape your professional identity as a lawyer? This question's a little bit soft, but Professor Nicole and I were talking about this, where it's almost like a chicken and an egg thing. Are you a reflection of your theory, or does theory influence you? Is what you've done, I mean, I've become an educator. I was a lawyer working on Wall Street, and now I'm a teacher. So my values are very much laden into what I do. My theory, I suppose my sense of self is very much apparent in what I do, how I teach. And so I wanted to ask that question directly. And I wasn't even planning on talking. I sort of was thinking, oh, I'm just a skills professor. What do I have to add to this? But I have something to add to this. Not surprisingly for myself, you know me. I was thinking that basically, yes, theory does have a place. But I want to be careful about overstating its place. What I do, as I mentioned, is really teach basic skills. And so one of the skills I was thinking about was this idea of case briefing. Do you remember briefing a case? Yes, this is idea of dissecting a case. We're learning how to read a case. What is the issue? What are the facts? What's the rule? What's the reasoning? And then I got, wait, reasoning. That's an interesting piece of a case brief, and that's where theory might come in. And I was thinking about this case, Sirocco versus Geary, which is that classic, there's a big fire, and it's a public necessity case, and a house is destroyed, and it's destroyed basically to prevent the spread of this fire, which made sense at the time. It was 1849. And I talked about this with my students, and I could imagine how, there's actually a little quote in that case. So I'm so off my notes because, that's what happens. The right to destroy property to prevent the spread of a conflagration has been traced to the highest law of necessity and the natural rights of man, independent of society or civil government. That is a line from this case that almost all of our 1L students are reading. And what is that? That's a reflection of classical legal thought, natural rights of man, law from above. And how many of our students are or should be recognizing where that comes from, the value of that. Because if we contrast that to a case like the one Professor Fleming was talking about, where Williams versus Walker Furniture, which is done in a different judicial period, a different era, where we see a different sensibility of the court, would it help our students to put something like that in their reasoning section? Is that going to deepen their education, and ultimately is it going to make them a better lawyer? I think it is. I don't think every case lends itself to that kind of a dissection, but On a core level, reasoning is legal theory, and it is not just, as my students will struggle with, well, I've already stated the rule, and my reasoning is just I'm applying the rule to my facts. It's actually deeper than that. It goes to a historical perspective. It goes to a theoretical perspective. It goes to that judge's own sense of the case. The other sort of last thing, I teach a skills class called client counseling in the summertime, which is wonderful to teach a summer class. Everyone's in a good mood. And we talk about this idea of client-centered counseling, which I just took for granted as just, of course, we represent our clients. These are our clients. They're in charge. They're empowered. But that in and of itself is a theory that reflects the relationship between the lawyer and the client. And so that's embedded in mine. It may be a soft theory. It's not how we dissect or interpret law, but it is a sense of self as we are teaching our students how to be lawyers. And so on some level, there's some theory there. Again, kind of picking my brain to think about how does theory fit in with what I'm teaching. And then I asked several of my good-natured colleagues here at New England Law, do they use theory in their classroom? And it was really interesting to hear their responses because it was a provocative question. They were asking themselves, do we use theory? And the common answer that I got was in first-year courses, we do. We're careful, but we do. We talk about it on a broader level. Was this the right result? Where does the law come from? Is this just? And then on some of the higher levels of teaching comparative law, which Professor Nicole will talk to, we understand where law comes from and we understand ways to evaluate law so that we can compare laws and we can have a deeper understanding of what the right legal system really is. So at the end of the day, I think where I come out is quite enthusiastically, and I'm inspired today by the conference to think more directly about incorporating theory into my classroom, even in a basic academic skills class where I'm teaching them how to plead the case. I want to call their attention to it because for some of the students, this is going to be meaningful. Some law schools are churning out Supreme Court justices, others are churning out practicing lawyers who are out there representing individuals with cases, and we want to give all of those students the education that they deserve and are here asking us for. So it's not a one-size-fits-all, and I think that, from my perspective, I'm certainly inspired to use it more, and I'm curious to hear from those of you in the audience who are teaching, as well as our panelists as well, a little bit the answers to all of our questions. I want to start by turning it over to Professor Nicola to answer that first question, but then also you do such interesting work. I'd love you to share a bit of your background with the audience.
So thank you so much, Lisa, for putting it so well together, and it's so wonderful to be back here. I taught as an adjunct here in 2005 and 6 European law, and so it's great to be back. And then I started my job in Washington, D.C. at American University, and I teach comparative law, and I'm very interested in the globalization of legal thought, and especially how U.S. legal education is very globalized, and there's something that American law schools do and do well, that is they teach at a very practical and theoretical level, as we heard throughout this conference, so that it's very exportable. And it's a type of legal education that I tell my students, no matter what, just the fact that you receive a legal education in this country will put you at an advantage in the world. And so after this little advertisement, though, I was thinking of Lisa's premise about the lack of theory, and then I realized I also wrote something about legal education right now in the U.S. is under pressure to abandon the self-reflective practice of law committed to social justice. We heard in the presentations on Crackdown and the UCC that there's a tendency to become a practical skill set serving the interest of a client, of a government, or a lobby group. As a result, the diffusion of U.S. legal thought as a unique method combining theory and practice is not really declining, but its methods and politics are undergoing a stylistic and substantive policy transformation. So in my work, what I do is I basically train U.S. lawyers from when they go out there and they go and engage with the world at large, and they mostly they are involved in organizations such as the World Bank or other the ABA Rule of Law initiatives that try to reform law in other countries, and they start with the understanding and good knowledge of their U.S. law, when they go abroad, what do they have to do to start reforming the law of another country in either banking law or corporate law, and I think the presumption already to go out there and reform someone else's law is already a big presumption, but the U.S. is a powerful country, and this legal education has created a group of lawyers that do that skillfully. So I basically caution them, and I use some of the insights from American legal realists to say, in your legal education, you've been cautioned throughout in doing legal reform. And even though, and I would say, a famous professor from this law school, Mary Jo Fruit, that was at the beginning of this conference, cited that law is a constructive force. We really have to start from concrete problems. And I think law is a wonderful force, it's a constructive force, it's a force that brings about legal change, but when we decide to use it, we have to have some caution. And so I basically ask my students, when they do, for instance, comparative family law, which is very en vogue, and it's very, Llewellyn wrote 2 articles that were mentioned here, Beyond the Law of Divorce in 1932 and 1933. Legal realists were very much committed to family law and understanding better the law of divorce. And so when I, for instance, ask my students, okay, what kind of steps will you take when the Women and Doing Business, which is this group at the World Bank that aims to reform family laws around the world to make it more efficient for women to go back to join the workplace, with the presumption that this will improve and create more growth in certain countries. I asked them to take some steps, and the steps consist in step 1, understanding what is the purpose of the rule they're trying to change. And so asking really, observe the context. Let's say they want to introduce a no-fault divorce in a country that doesn't yet have no-fault divorce, and there's still some of those. But they really have to do some observance, and they have to be like anthropologists, understanding the law on the books and the law in actions. And they really have to be cautious and observe, as Professor Fleming was describing. They have to do lots of observation and understand what are not only the legal but also the social and cultural norms in place. The second step is really to understand how the family law rule, or the particular rule they aim to reform, is certainly correlated with a web of other rules that derive from tax, child custody, child care, labor, welfare, and how they overlap with the rules we want to reform in a particular context. Step 3 is to move ahead in understanding and bringing the so-called comparative perspective that is not a one-size-fits-all, but legal change can happen by adopting a little bit of some rules that come from Nordic models and other rules that come from a Southern model or Eastern or Western, and really depending what is the scope of the legislation that you want to adopt in a particular context. And the last step is really how do we implement the rule, which goes back to the crackdowns, like how do we do the enforcement part. And here I think the whole Llewellyn insight about the consequences, and there's lots in this work, and the work of academics, and not only academics, has been a lot about the backlash of legal reforms around the world, the unintended consequences, and also the fact that often we disregard the kind of alliances that are in place, or the groups that are in place in certain contexts, and we don't understand the way they're empowered, or that we could leverage alliances among social or professional groups to basically achieve a better outcome for that particular legal norm that we want to reform in certain contexts. So going back to the first question, is there a place in theory in the law school classroom, and if so, how do you bring it to your classroom? So the way that I do it is really by cautioning my students in understanding the limitations as well as the potential for legal change, Law is, of course, a constructive force. It's important. I would never, Nicholas Kristof wrote in the New York Times that it was impossible to reform family law because it was so connected to the social norms of society. I would disagree on this point. I do stand with the women and business and the law at the World Bank, but yet I'm always wary about what kind of change we can create and go about, and how we have to see these changes embedded in the economy and the society of the particular context where, as many of you told us before, we have to use the practice to understand how the reform works. So I would open it up for other contributions in this field, especially not only banking lawyers, consumer lawyers, feminist legal scholars, and open it up to...
And if you don't mind, we'll start with Professor Nyquist, whose teaching I have much admired. And I'd love to hear, because what you talked about is deep and thoughtful. How do you bring theory into the classroom? How did you bring it?
So my goal was to have theory in every class meeting, not just in every course, but in every class meeting. And I didn't always succeed, but I thought it was, something worth trying. The really challenging courses were the upper division UCC courses, where you had 100, 120 students. So I would pick an article. Duncan's Form and Substance is perfect for this, and then I broke that into maybe 15 pages, and every day there would be 5 minutes for theory. And I emphasize, this is the best part of the course. This is the part of this course that you can take and apply throughout the curriculum. And I would break the article down and talk about it, the component parts. Talk about rules, talk about standards, how are they different. You'd read a section of the article, and then I'd have the students look for examples in Articles 3 and 4, rules and standards, individualism, altruism as policy arguments. I would have them look for those arguments in cases. I think it worked. Maybe it was 62% of the students. The rest just didn't buy into it, but I would test on it. I told them that. But as the semester would develop, it was this constant movement from the particular to the general, moving back and forth. And that was the ultimate goal. I wanted the students to be able to think about a statutory section and then apply the principles. Is it a rule or a standard, some combination thereof? What would be the policy type arguments that you would make about that particular section? And, in first year classes, you just tell them day one that policy is important. They write it down, believe it. So I never found that was a challenge. And then I had a seminar in contract theory, so that was a self-selected group. So I thought it was incredibly important, and it made teaching fun for me. And it was a part of the particular classes where it was kind of an adventure to see what the students would think of this. And so that was my technique.
All right, Mr. Sahani, do you want to weigh in on this?
Yeah, sure. So I teach civil procedure, which when I started teaching it, I didn't think of it as a class that really had that much theory in it. But over time, I've come to realize that teaching sort of the history of the development of legal concepts is really important, and explaining, especially just in the area of personal jurisdiction, explaining how the transition from lawyer to international shoe requires, it requires an understanding of the underlying theory there. Another class I teach is legislation and statutory interpretation, which is essentially a class about theory, with a bunch of useful rules of thumb for reading statutes also included helpfully. But the class that my students enjoy the most in that course is a class that's all about theory, and it's about it's about realism and progressivism, and then about about Hart and Sachs and the development of legal process and the writing of the samizdat of the legal process papers and its dissemination through the legal academy and the clerkships of John Roberts and Henry Findlay and so on, and just why it is that everything they read is always written in the exact same form. Why is it that we have this template that is always followed when we write briefs, when we write opinions? Where did this come from? And so I tell them that this is the class that's about the playbook. That this is about why the law that you read is always written in this way nowadays. And this is why all those old cases look so weird. And this is why your memos are written in this way, why your briefs are written in this way, and it's all because of theory. And I know I teach that in a very my education was very heavily inflected by Hardy Wexler, Fed Court's model, and so I pass that on to them, and I say this is how I look at the world.
Let's turn to the next question, and Fernanda, if you would mind reading us out.
Sure. So the second question that Lisa put out there is legal theory even relevant to the practitioner struggling to represent or advise clients? So I also teach, I have to say one more thing, that a caveat that I teach tort law. And when I do teach torts, what I'm doing these days with intentional torts as we speak, I really try to build for my students better and the classic issues of the right and the privilege, the rules and standards, the policy and the counter-policy arguments, and I leave them with lots of indeterminacy and legal outcomes, and I bring my students in what you could call uncomfortable places where they really are not at ease with the outcomes. So think about O'Brien, SJC case at the Massachusetts Supreme Court, where my students end up saying, oh, of course she didn't consent to be vaccinated, she was this poor immigrant from Ireland, she raised her hand, but at the end of the day, many people are left uncomfortable in the classroom and they don't want to speak and they'll come later to office hours. So I think the legal theory is relevant to show how this built-in indeterminacy of legal doctrines in terms of outcomes is there, while, as I think Mila was saying, it will show also the rationality of the legal process and this playbook. There's a certain kind of rationality in the way we briefs and the process works, and the rationality is not so much in the consequences, but more in the process. So lawyers, my students become lawyers, my hope is that they understand how to use substantive and procedural laws and their interplay, so that they always make use of theory into practice and interpretation of law in which they have lots of discretion. Lawyers have a great discretion. They're really free to shape legal doctrine. They create new standards. Yet they're also constrained by legal ethics, as we heard from the beginning, also procedural rule of the professions. So even in adversarial situations, when lawyers are asked to represent a client they disapprove of, right? As lawyers, they can make choices. These choices are based on their moral beliefs that the law should not erase, those should stay, but they're kind of, the moral belief is that they have commitment towards themselves, towards the entire society, and they can decide not to take a client's case who's using his legal right or her legal rights in a bad case. So legal theory, I think, for a practitioner might shed light on the idea that lawyers have a conscience. It's the legal consciousness of lawyers that is based on different political, moral beliefs, and they can make better, good choices to distribute what they have, which are legal privileges. They have basically acquired through their legal education, so they can distribute these legal privileges according to fees, but also other issues, accordingly as they think they should, according to their moral beliefs. So this would be my take, but I think Kurt might have another take, Mila and Lisa.
So I certainly think that the answer to that question is yes, except I guess with the word struggling, I think may convey the impression of somebody who's like a solo practitioner or working pro bono. In my teaching, I emphasize how legal theory can also be very useful to those who are representing or advising very well-resourced clients. And I do this in my class on, I have a seminar on the Affordable Care Act, or what is currently the Affordable Care Act, to see how that goes. You know, it's in the constitutional law attack to the Affordable Care Act. We saw how it was entirely dependent on the creation of new legal theories about the Commerce Clause by Randy Barnett and others. You know, in the statutory interpretation issues that have been raised by the Affordable Care Act, which were ultimately resolved by the Court of King, we saw the justices debate theories of statutory interpretation and engage sharply, to disagree sharply on the proper role of courts in interpreting statutes, which of course relate to broader theories of democracy. So I teach that. And then in the various administrative law issues that the implementation of the Act has raised, you know, we see implicated all of the law and the theory that implicates the regulatory state. So, you know, presidential administration, the law about law enforcement, you know, the amount of the theory that surrounds all of the theory that surrounds administrative law. So I just in that entire class is for me is a course that's essentially about how legal theory can be translated into lawsuits, and the Affordable Care Act has shown half a dozen situations where that has already occurred.
So Steve wants to.
Yeah, I would just really add to that. One of the importance of like thinking about legal theory is it makes you self-aware that you don't want to let what you're doing in practice, the legal doctrine, drive you. I mean, the Randy Barnett to come up with a new theory that reconceptualized something a new way. They're not thinking in the old channels of doctrine. And I think when you talk about legal theory, it can make you aware that you're reacting, doctrinally. And that can be the worst thing for your client. Your client might have a loser. I mean, when you presented your paper on, if we looked at traditional separation of powers and all of those traditional lines of thought, as you point out, they're formidable obstacles. But sometimes, you have to think outside the box. And if you're not attuned to that, I think your clients are disturbed.
So many of the best lawyers I've known are interested not just in the practical literature field, but they read theory.
Yeah.
And not just in law school. So one of the reasons I include theory in my law school courses is to show the students how interesting this is. And as you graduate, hopefully you'll continue reading in theory. So that's part of the goal here. And I think you're right. It gives you a breadth and a depth in thinking about the law that is just not available if you're just looking at statutes and recent decisions and not thinking more broadly about the laws.
Yeah, so essentially, this is fantastic, by the way. Essentially, you're encouraging students to be more mindful, right? To ask why, right? What you said about first-year law students and how you just tell them policy, and that's what it is, right? In a general concept, that the problem is that people are very gullible. Right, they're gullible to seeing a headline on a news station and determining, okay, that's fact. Nobody's asking why, right? Because they live externally, not internally. So self-awareness, right, is very important because you ask why, you question life, because theory is life, right? You start to discover things and understand yourself. You live internally, from the heart to the mind out, not externally. Seeing a headline or somebody says something in class and you believe it's fact, okay, that's what it is. Encouraging mindfulness is the key.
think that's a very good point, and I think one of the things in your legal education, figuring out what you take in, how you take it in, how you process, and have some discretion about what you hear, and be critical. The critical thinking skill that I think you're talking about is very critical. It's very important in law school. Yes.
Do you want to finish up this, or should I just go ahead? Did you want to finish up the third question, or can I just?
Do you want to answer the third question?
No, I'll answer all three questions.
Yes.
The first and third questions, certainly for me, as someone who's always practiced for large firms and lesser now, and also I've taught for 24 years, sort of all intellectual property and commercial law, antitrust from the old days, etc. I mean, I think that, as I mentioned earlier, I find it about 1/4 of the students even want to listen to the period issues and the history, let alone theory, but I do, because that's what I do. And, so answer first and fourth question, yeah, I certainly believe that. But I will say that in my experience, there's been a real transformation in the past 40 years in the legal profession that's changed, that my answer to the second question is probably no. It's not really relevant. That essentially, 40 years ago, the big law firms, for example, the rainmakers basically sold the firm, not themselves. So consequently, they came to places like this, or the American Law Institute, or the Uniform Law Commission. We don't see those people there anymore. Because once we had mobility for the rainmakers, they're out for themselves. They're not trying to build the brand reputation of the firm. So we don't see some of the basic figures. So 40 years ago, at a big Wall Street firm, our firm was willing to say to Mobil Oil, we do not bless your acquisition. You want to get a white paper, go talk to one of the VC firms. And we wouldn't say that today. No one would say that today. And the idea is that we had a different statute. The passed over associates of big law firms became general counsels at the big enterprises. And of course, they would listen to us well. That the big companies, big Fortune 50 companies, had general counsel who were former U.S. attorneys and stuff like that. They had face. Even they have no power today. Basically, Facebook or whatever, you don't have that kind of respect. So the lawyers aren't really in those policy decisions. And the other, and also what's happened, and coming from the Uniform Law Commission and otherwise, what's become much more important are lobbyists. You can earn your $25,000 or $50,000, $100,000 retainer by changing one word in statute. Well, gee, that's compared to lawyers who might take 2 generations to change a common law. And fewer and fewer people care about common law. So in the practice, in intellectual property, this is big stuff. No one seems to even care about history past the last division in the statute. You look at the legislative history and you try to argue that some of the big firms may come up with some novel theory, but there aren't that many.
So you're answering the second question, no.
Yes.
I want to call upon my dear friend Joe Berman. I hate to put you on the spot, but you have a variety of backgrounds. I think you could speak to this from private practice to your current position now.
So I guess I disagree to some extent. I think I agree with Professor Nyquist that theory, and I was for 25 years a workaday trial lawyer, handling many cases in the court every day. And on the one hand, I was very practical, and you sort of focus on the case in front of you, and you try to do the best you can to advise your client or help your client win. But I do think that there is that theory, that background in theory and public policy, whatever you want to call it, that underlies everything that you do. And I think it makes you a better lawyer, it makes you a better thinker, which I think, and a better writer and communicator, which are the skills that I think all lawyers need in order to represent your client. And what we're learning is not just a trade or a vocation; it's a profession. And I think there's a difference, like it's like being a doctor or an academic. And so I think it's important. I think it's, somebody may have said it's sort of in the background. It's not always there. Obviously, you're not always arguing public policy or legal theory in every case. But I think it's always there. And I think the best lawyers are the ones, and the ones who do really well, are the ones for whom the law is really exciting and a great way to make a living, are those who really kind of see the larger picture. Even though you have a small case in front of you, you can sort of appreciate the larger picture. I think that keeps us going through all the client pressures and everything else. But I will agree with you that the law has, I think, in today's hyper-competitive environment, and has lost some of its luster to lobbyists, and I find that very sad, because I care a lot about the profession, and I think it's important that we have that, and I think maintaining it as a profession is a crucial point.
Well, I agree.
Too much government and the media.
So we have a few more minutes. Oh, wait, yes, you're blocked on the outside.
So I had class basically all day, so I missed most of this. So I'm wondering about a question that I wanted to address. What I hear you talking about are some very standard, well-known theories, well-acted natural law and realism and all this kind of stuff. What I also hear you talking about are theories that are integrated or classroom, talking about commercial law classes. So, and maybe it's not a question, because the truth is I don't hear as much as I used to. But there are a bunch of other theories that nobody's talked about. And also there are courses in themselves. Critical race theory, feminist theory,
Law and economics.
law and economics, queer theory, or all of those. So the question is, how about them? Do we think about them in a different kind of context? What do we think about the idea of them being courses in and of themselves? And are they, do we think that some of those theories are actually useful to the practitioner in his everyday life? I'm just curious, not knowing who's talking about it all today.
Well, I mentioned earlier Mary Jo Frug article, Rereading Contracts, Feminist Critique of a Contract Casebook. She has a wonderful discussion in there about the Parker case, Shirley MacLaine.
Picture of the book.
Yeah, and it's a very fascinating discussion of the difference between individualism and altruism. And it turns out that Shirley MacLaine is arguing the individualistic side of that, and the studio is arguing the altruistic side. So it's kind of a mind-bending experience for students, because it undermines their assumption about gender roles. I think that's exactly why she chose that case. So there's a long history, I think, of feminist literature and engaging with theory at a very practical level. Mary Jo was great at that.
So to answer to your question, I think the idea is that even if the class is called, feminist jurisprudence or critical race theory, the move of the theory, the move of the critique is something that you will encounter in everyday practice. Think about, I was just hearing a paper on criticizing the post-racial thinking, how that wasn't effective, and we're seeing what we've experienced in Charlottesville is the fault of thinking in a post-racial way. And the analogy was with Patricia Williams' attempt to say, well, in critical race theory, we don't want to give up rights just right now. When CLS were attacking the rights, thinking critical race theory was still attached to the moment of rights. And so I think that those moves are moves that you can find again in whether it's talking about the UCC or whether talking about discretion of courts or legislatures. I think theories, whether you teach it as a course that is called feminist jurisprudence or contract law in UCC, it's always there. However you package it, that will come back for practitioners or for lawyers to help them make those moves and those critiques.
I'm a working lawyer, and from my perspective, from the trenches, I think people that go to court use legal theory every day. They have to have a model of how the judge makes a decision. Is the judge applying the law to the facts, come out with a predetermined outcome, or is it more of a jump ball? I had the privilege of having someone in one of my classes. We were interpreting a statute, and he was a disciple of Professor Nyquist, and he pulled out his counter thrust. He's quoting Hal Wellen. Stole the show.
That's why I retired.
But the point is, if you're litigating, you have to think about theory. Another practical perspective: if you're arguing, more focused, you're arguing in the Seventh Circuit before Judge Easterbrook or Judge Bosner. If you don't address the law and economics approach to the problem, critique it, or if you don't address their theory, their explicit theory, you're not doing your job. Or if you're talking to a client, and this is what the law is, you've told me your version of the facts, and they want you to make a prediction. What's going to happen? Well, I think if you go back to the Thrust and Parry article, anything could happen, to tell you the truth. There are limits. There's a limit to judicial discretion. There are appellate courts, but you're always thinking about theory, and it might be like Voltaire. You discover you're talking prose, but I just think, for our friend here, you'd be mindful of it. You're doing it, but you're not conscious of it.
Unfortunately, among my colleagues, the judges that actually think about theory are viewed as really obstructionists, and that's how it's changed. I think that as a practicing lawyer, going before the bench, the federal bench in the District of Massachusetts, the few judges who actually entertain theory, they said, no, we don't want to have those judges. And this I think is very unfortunate. But that seems to be what's happening.
So our program promises a social hour, which means that we can continue the conversation, and I really appreciate. I want to acknowledge Professor Monson.
I just want to do it.
Sure, absolutely,
Right.
by all means, yes.
There you go. Shout out over here to John Breyer, second year student, working all day, and thank you very much. Professor Nicola, we also copied an article from yours. What was the title of that?
Comparative family law exception. Exceptionism of comparative.
Copies over there, if anybody wanted to follow up. And then I was just gonna, I put this one sentence together. Let's see what harkening back to Professor Goldberg. Whether we're talking about speed traps to enhance the town's revenue, or UCC 4406 on bank statements, or Walker Thomas Furniture's attempt to repossess Mrs. Williams' stereo. Theory is always operative whether we name it or not. And I think the wonderful thing that Professor Freudheim and all of you and the prior speakers have done is you've really gone a great distance to chase theory out of the shadows, really into the light. And I think that is a very useful thing to have done. Thank you.